Welcome to the monthly Truck Stop webinars brought to you by the Motor Carriers Insurance Education Foundation. Truck Stops are presented the second Thursday of each month at 2 p.m. Eastern Standard Time. These webinars are presented as industry updates for information purposes only and do not qualify for state CE credits. However, the foundation does provide state CE credits in a different time frame. If you're seeking state CE, email our office at trs@ibci.net, and we will send you information about CE opportunities. During this presentation, you might have questions. Please type them in the chat window, and they'll be answered as time allows or later by email to everyone if they're generic in nature. If you experience any problems, please send us a note in the chat window again or call our office at 800-741-4084. We'll attempt to correct the problems as soon as possible. These webinars, after we're finished in about 2 or 3 days, will be posted on our website under the Truck Stop, the Transportation Risk Specialist website and the Truck Stop, and you can download the information that you might want to look at in more detail and or share with some of your insureds. Our friend in Winter Haven, Florida, Bridgette Blitch, has helped us in the conference and does things. And she and I were talking the other day, and she let me know about some changes in the Food Safety Modernization Act that will increase the compliance records. And also there's a couple of court cases now that we've been involved in this over a year. So Bridgette, I asked her to come back today and share some update information here and also maybe some future projections of where this act is going to go. Bridgette, welcome to the webinar.
Tommy, thank you so much for having me. Always a pleasure to be here and to share some insight and some experience that we've gained for almost about a year since the Food Safety Modernization Act came into effect for our insured friends, motor carriers, shippers, receivers, and loaders. So a pleasure to be here.
And as you recognize, Bridgette, since my father's a pickle hauler, these things are very interesting to me because pickles are food, even though I don't like them.
Yeah, that's always a good debate, right? Well, let me start us off here with just an overview of the Food Safety Modernization Act and what I plan to cover here in our presentation. So just in case there's anyone in our audience that hasn't had a lot of encounters with the Food Safety Modernization Act, I'm just going to kind of go through the basics of what this law requires for parties who are subject to the act and identify again for the audience who those parties are. And coming down the pipeline, there's going to be some new folks that are going to be exposed to these requirements this year in 2018. So we're going to talk about that. We're going to talk about what has been seen in the industry over the last several months since April 2017, what parties that are subject to FSMA are doing to be compliant with the Food Safety Modernization Act, and then also parties that may not be subject to the Food Safety Modernization Act are still feeling the effects of the law based on contractual requirements that are being passed down to them. So we're going to look at the impact in the industry. And then we're going to talk about some cases that are new to the industry, 2016, 2017, rarely recent, just to see if we can get an idea of how courts might address a claim that comes up through a rejection of cargo and the interplay between the Food Safety Modernization Act and the Carmack Amendment and common law theories of claims. So we're going to take a kind of a journey through some of these recent cases that I think could give us an idea of what courts might look at if a claim comes down the pipeline where the Food Safety Modernization Act has been in effect. And then we'll look at.
I was just going to say, yeah, of all the things you talk about, us helping our insured understand is actually important, but what you just talked about is the most important thing, because it affects us two ways. Do we have the right insurance coverage if we are a retail agent? And insurance carriers, how are you going to handle some of these claims when there might not be, quote, damage and other things? So how the court's leading us to have a load rejected. Now it falls upon the insurance provider to determine what should be paid or not paid. That's a relevant part of where we're going. And we always thank you for and other people in your firm, Jay and Robin, all for bringing these court cases to us to give us guidance on how these things will be handled as we look at the policies we're issuing.
Yeah, that's exactly right. And that's where the last piece of this is, what should your insured do next? So let's take some of these guiding principles from the cases that we're going to talk about and look at what can the insured do to reduce their risk of liability exposure in claims and be best prepared to comply with the Food Safety Modernization Act if this is now going to affect them, or if they've got now duties that have been delegated to them from the Food Safety Modernization Act coming into effect last year. So that's going to be the recap of what we're going to be doing under the Food Safety Modernization Act. And so let's just kind of talk about, again, briefly, who are the parties that are subject to this? You're going to have shippers, which we know are including brokers, receivers, loaders, and carriers that are engaged in transportation operations. And last time, Tommy, we kind of went into some detail about transportation operations and what that means. And that's whether or not the food is being offered for or enters into interstate commerce. So the Food Safety Modernization Act is going to apply to those key parties there. And a carrier can mean a motor carrier, it can mean a rail carrier, and it's subject to, of course, some exceptions. But as I mentioned in the opening, we've got the Food Safety Modernization Act coming into effect last year, April 6, 2017. That went into effect for other businesses that are not considered small business under the definition of small business under the Food Safety Modernization Act. And there's that definition that has what a small business is. But as you see, a facility that has more than 500 full-time equivalent employees, obviously that's a substantial operation, except that for carriers by motor vehicle that are not also shippers or receivers, so those entities that are, say, have a transportation arm associated with them, this term would mean a business having 27.5 million or more in annual receipts. So it captures certainly a large group of FSMA parties, but there's now going to be, and we'll foreshadow more entities that are going to come under the umbrella of the Food Safety Modernization Act this year. So there's some exclusions that apply, and here's the list under the statute. That's food that is transshipped through the United States or another country, food that is imported for future export that is neither consumed or distributed in the United States, or food that's located in facilities that are regulated exclusively by the USDA, operating under the assumption, of course, that they're already taking measures to ensure that food is safe before it gets to the ultimate consumer.
Bridgette, you mentioned those things. It seems like this act only cares about U.S. citizens, not people outside of the U.S. When you look at what they're saying there, that's okay. I understand that part of it. But I never thought of it in those terms. In other words, it can pass through the U.S., but if no U.S. citizen consumes it in the continental and or Alaska and Hawaii U.S., then we don't worry about it. So that would be a kind of a strange thing added to it. But that'd be rare when they do that. That'd be some kind of warehousing and things like that probably would not affect many of our insurers. All right, let's talk about the exception here, because I think this is the thing that's going to be changed, is it not?
So this is part of it. Well, this is non-covered business. So this is a section where it says an otherwise covered entity. So a covered entity meaning our broker, shipper, receiver, loader, or carrier that has less than 500,000 as adjusted for inflation in average annual revenues, which, and this is on the statute, calculated on a rolling basis during a 3-year period preceding the applicable year. So here, there's some discussion in the industry of, well, there's certainly a large group of motor carriers that have less than 500,000 as adjusted for inflation for average annual revenues. And therefore, the discussion in the industry is that if you're an entity, if you're insured, has less than 500,000 in annual revenue, even though they may be a motor carrier, they're not going to be subject to the Food Safety Modernization Act regulations and all the provisions that are applicable to carriers. That being said,
let me bring this
yes.
to the thing. That's basically I assume revenue is revenue from the shipper, not net revenue if you have owner operator. So we'll talk about that thing. So if they have billings, and we already go back and look at Atra's discussion, other thing, you're talking about someone that maybe has 2 trucks. If they got the 3rd truck, they're going to exceed $500,000. So it's maybe someone with 1 or 2 trucks would fall in this exception. Once they have that 3rd truck, I think it would go over that. Do you not agree with me in 90% of the cases?
Right. So I agree. This definition, which was pulled right out of the statute, says a non-covered business, which I just identified the parties engaged in transportation operations. And these are looking at the actual annual revenues of that particular party. So yes, it would look at just the carrier, what their average annual revenues are calculated on that rolling basis during a 3-year period preceding the applicable year. So then, if there's a separate entity, a separate insured that is a shipper, for example, and they come under this $500,000 annual revenue, I think you could make the argument that they're a non-covered business based on this particular exception and definition that's in 21 CFR 1.904.
You know what I visualize in this, and you run it up certain times of the year, all these watermelon shippers that have the watermelon stands on the side of the highway who are shipping watermelons north, $500,000 worth of revenue, probably a lot of those would fall under that part of it in that area because, that's one of the seasonal crops where your farmer might fall under this, or the shipper of those watermelons might not generate $500,000 worth of revenue total. That would be interesting there. But basically, trucking, we're talking about somebody with more than 2 trucks would be subject to this. Would you agree with that part of it as far as transportation goes?
I mean, I think that's likely the group that would fall under this non-covered business. But yeah, I mean, and your watermelon stand. I mean, it's interesting. The shipper is a person, so it's very broad under the definition, such as a manufacturer or freight broker who arranges for the transportation of food in the United States by a carrier or multiple carriers sequentially. So if your shipper is if you're talking about a watermelon stand that's just sitting out on the highway, you can make the argument, well, they're not a shipper because they are not arranging for the transportation of food in the U.S. by a carrier or multiple carriers sequentially. But if you have a manufacturer, for example, that's bringing watermelons into the factory and producing them and sending them out to transport to a retailer or the ultimate consumer, then they would fall under the definition of a shipper.
Well, how about a grower? Would that be a quote manufacturer if they grow it and then ship it? Because a lot of these things are shipped north during the April, May season. Just thinking about the Florida exposure. Anyway, we'll go on beyond that, Bridgette. Let's go ahead. I'm sorry, I don't want to enter.
Yeah, no. Well, a grower could be a shipper if they're arranging for transportation to get their watermelons to a distribution center or a cooler. Before it ultimately reaches the end consumer.
Right. Okay.
So let's just kind of briefly recap what some of these duties are that are being imposed under the Food Safety Modernization Act. And we're going to go through our key parties here. And I'm not going to go into a great length of detail because we did that in the last webinar. But here, loaders generally must verify that each mechanically refrigerated cold storage compartment or container has been pre-cooled and prepared for the transport of food. So loaders have an important job. They need to ensure that the vehicle, that is the trailer or the unit that is transporting the food, is in appropriate sanitary condition. So what does that mean? That's making sure that there's no visual residue or mildew or anything that the loader can identify that could compromise the safety of that food being transported. If it's a temperature controlled food product, they need to make sure that that reefer has been properly set to accept that food for transport. And so the loaders have an obligation to, for their part, ensure that the food has been placed in a vehicle or equipment that is safe for transport.
Bridgette, let me ask you this question. Definition of loader. A loader in a drop and hook situation could be the shipper, but a loader in another situation, depending on the contract they sign, could be the motor carrier, could it not be? Or in some cases, we know about lumpers and the third-party loader. So it could be any one of those three parties that would have this responsibility, depending on the contract that the shipper has with the motor carrier, could it not?
It could, and the definition under the Food Safety Modernization Act is broad in that it's a person that loads food onto a motor or rail vehicle during transportation operations. So it can cover any number of parties that's wearing that hat that's responsible for shipping and that is putting that food into the vehicle for transport.
Okay.
So shippers, and there's certainly a large swath of regulations here applicable to shippers, but we're just going to really kind of condense this to shippers must specify to carriers in writing all necessary transportation specifications for the carrier's vehicle and transportation equipment. And what we're seeing, and this even predates the Food Safety Modernization Act, but food shippers very detail in their contracts setting forth the requirements of what the vehicles must look like or how they must be maintained before food is placed into the carrier's equipment. And so what's really important here is when you have those contractual requirements or those written requirements that are passed on to the carriers, that those carriers are actually reading their contracts and making sure that they're adhering to whatever specifications the shippers are passing down to the carriers. Now, if the shippers don't provide in writing these sanitary specifications, then that's going to be an issue where the shipper has failed to communicate what the necessary responsibilities are to the carriers. And it certainly, go ahead.
I was thinking about, and Carmack, that last example you had would clearly be, we would not maybe have to pay that because of shipper error because they didn't notify us of those conditions. Is that not what you would think that would be where we would possibly deny the claim because we weren't told how, our insurers were not told how to take care of it? Or
right. So if this is a situation where the Carmack Amendment applies, and recall that as you know, Tommy, the Food Safety Modernization Act is not a claims handling statute. It's a provision to ensure that food is shipped safely before it gets to the end consumer. But in a situation where the Carmack Amendment applies, once the shipper has met its prima facie case under the Carmack Amendment, which we're going to talk about here in some of our cases shortly, then the burden comes back, or the motor carrier can raise an affirmative defense that it was an act of the shipper. So if the shipper fails to communicate what the temperature requirements are, or misidentifies, let's say, what the temperature requirements are for a shipment, then I would raise that as an affirmative defense as act of the shipper, and therefore there should not be any liability that's passed on to the carrier in the event of a claim.
Thank you.
So, yeah, you bet. And shippers must also develop and implement written procedures to ensure that vehicles and equipment used in its transportation operations are an appropriate, and this is kind of the broad strokes, appropriate sanitary condition for the transportation of food. So here's where shippers now, if they haven't already done so, have to have actual procedures, quality control procedures to ensure that vehicles and equipment are ready to receive their food products. Again, we'll see a lot of this being passed down through written quality control procedures that are incorporated into contracts or incorporated by reference into contracts. All the more reason why we want to make sure our insureds know what they're signing or what obligations they're taking on before they accept that shipment for food shipment for transport. Receivers. Okay, here receivers have been a big player in the Food Safety Modernization Act since April of last year. They, upon receipt of food that requires temperature control for safety, must ensure that the food was not subjected to significant temperature abuse during transport. All right, and Tommy, we'll get into some of the fun that's happened from receivers under the Food Safety Modernization Act. Then, of course, we have our carriers, and carriers meaning rail and motor must ensure that vehicles and transportation equipment are appropriate to prevent food from becoming unsafe during transportation operation. And that can mean a number of things. Carriers must also be able to offer specific information to shippers to confirm the safe transport of food, such as temperature control during transport, so reefer download, for example. And carriers must develop and implement written procedures as to the carrier safe practices regarding the transportation of food, such as cleaning and sanitizing of vehicles and equipment. Now, some of these more procedural tasks that have been pushed onto carriers under the Food Safety Modernization Act can be accomplished through, and we'll get to this at the end of our presentation, Tommy, but different consultants that have worked with carriers to ensure that they are putting the written procedures, the training in place for food safety compliance, and also the record retention requirements that have now been implemented under the Food Safety Modernization Act. So, Tommy, what's next? Well, you know, time flies when we're having fun. So here we are. April 6th will be here like it's tomorrow. And who now is going to be affected by the Food Safety Modernization Act? Now we're going to pull in small businesses. So those are businesses that are fewer than 500 full-time equivalent employees, right? Before it was more than, now we're less than, except that for carriers by motor vehicles, it's the same definition, that that are not also shippers and receivers. This would mean business receipts having less than 27.5 million in annual receipts. So now we've closed the gap. Before it was 27.5 million and above, or a non-covered business, meaning if you're between that gap, you're now going to get pulled in. So if you're 27.5 million and below, and you're a small business, and you meet one of the definitions of you're a shipper, a loader, a receiver, or a carrier, you're going to get pulled in unless you're a non-covered business, which is what we talked about, having $500,000 in annual receipts or less. So there is now going to be a substantial new group of people that are going to get pulled into the Food Safety Modernization Act requirements. So over the last almost year, we've had a lot of different issues that have come up in the industry because of the Food Safety Modernization Act. There's been instances of wholesale rejection of cargo. There's been new theories on the Carmack Amendment, and this is, and I'm not through case law, let me qualify that, but through what has been discussed in the industry. There's been new contractual language in the insurance contracts. There's been now requirements that have been added to contracts that allow shippers and receivers to conduct audits of motor carriers or brokers when duties have been delegated to them under the Food Safety Modernization Act. And we have now the enforcement authority behind the Department of Justice, where this actually has some teeth to it if there has been a violation of FSMA. So one of the biggest issues that we'll start with is there a right to reject? A lot of what I have seen over these last several months is shippers and especially receivers, right, who now we talked about have the obligation to make sure that the food wasn't compromised during transport, saying we don't have verification that the food product was shipped at a consistent temperature throughout transport. Therefore, we're going to wholesale reject it. And maybe that's because there wasn't a temp tail or a reefer download immediately available. Or maybe it's because the product in the trailer was shifted. And we're going to kind of talk about some of the cases where there's been a shift of cargo, and certainly we've seen this in other contexts where shifts in cargo lead to allegations. Well, just because there's been a shift in cargo now means that the food's been or the cargo's been compromised. So we're seeing a lot of different spin-offs on wholesale rejection, because receivers are very concerned that if they don't have all the information to ensure that the food was safely transported throughout the entire duration, that they've violated the Food Safety Modernization Act. So here is, and I pulled a comment from the Federal Register leading up to the enactment of the Food Safety Modernization Act, and our audience can go back and read this in a little bit more detail. But it doesn't say that there's a right to reject. What it says is that the rule does not require a receiver to reject a shipment that is transported under conditions that deviate from those specified by the shipper to the carrier and loader in accordance with the statute. The rule, however, does establish requirements that for parties who are subject to FSMA, that before the food is placed into sale or put back into the stream of commerce, that if there has been any concern that there's been a material failure in temperature control or other conditions during transportation that could render the food unsafe, that a qualified individual has to ensure that that food has not been compromised. And so we've seen that in the regulations, that the parties are free to designate who this qualified individual is that is going to make this inspection. But the bottom line is that there is not a right to reject. Rather, it is the obligation of the receiver to ensure that before food is put back into the stream of commerce, that a qualified individual makes an inspection of that product. And what is important for our insureds is when we have situations where our customer has said, we're rejecting this. Maybe it's because it's delayed, right? Maybe because we had a driver that ran out of hours of service. Or maybe we got a flat tire and it delayed us in getting to the window whereby this product was going to be received. And it came 24 hours late, and now we've got a rejection by the receiver. So in practical terms, when our customer says, we wash our hands of the shipment and it's yours, dispose of it, we need to ensure that the motor carrier is getting an inspection of that shipment, so that if that claim comes down the pipeline from their customer, that they can say, you wrongfully rejected the product, and there's a duty that you had to mitigate your damages, and here's what the value of the product is, and here's the inspection, here's the photograph, here's all the evidence that we have to show that either none of it was compromised or only a very small portion of it was compromised, whatever the situation is. But we need to make sure that that evidence is preserved so that we can push back in the event of a claim to say, no, we did our due diligence, we got and preserved all the information to show that there was no damages, right? Because that's, if we're looking at a Carmack Amendment claim, that's one of our prima facie elements is, was there proof of damage, which is then construed to mean actual loss or injury.
Can I step back for a minute with that then, Bridgette? As you know, when we first talked about this, I use the example of my father, who would not haul watermelons on because if they don't get there on July the 3rd, they're not worth the same July the 5th. So a lot of this stuff is a time frame consumer need for a market value here, not the long term. They're going to manufacture it and this kind of stuff later. So I see that some of this rejection could come from the economic view that the shipper just doesn't want it now because the time to sell it's over or something wrong here. And that's the first part of here. And then I'd ask you to think about that. But the second thing is here, all the time when we have a load rejected, it's standard procedure that our motor carrier can then salvage that load and then keep the revenue from that salvage and take their fees out of it and then provide the shipper the balance of that salvage. But what I'm hearing you say here, unless they get a third party sign off of it that says that it is able to be put in the marketplace, then we might have waived the ability to do a salvage or to sell it to a third party.
So every case we're going to have to address, right, which is a case by case situation. But let's say that our customer, that our clients or insured customer says, do not salvage it, right, because they don't want to have a DOJ enforcement action knocking on their door. Then that means that the motor carrier can't mitigate their damages, and the shipper has refused to mitigate their damages because they're directing us to dispose of the product. In which case, we still need to get an inspection of that product because we'd like to be able to establish or push back that there has not been any damage to the product before it was disposed of or before it was dumped.
That's that first question, legitimacy of the rejection is what you're talking about.
Correct. Now, if the customer says that this product is yours, you own it, and they don't give us instructions to dump the product, then yes, the carrier generally would have a duty to mitigate their damages, which means that they're going to go through the same process and they're going to get an inspection because they have to make sure, right, that this product was not subject to any time, temperature abuse, and that it's safe to put back into the stream of commerce. So we're a carrier. As carriers, we're still responsible for complying with the Food Safety Modernization Act. So the inspection does two things for us. One, it helps protect us in the event that somebody tries to claim that we violated the Food Safety Modernization Act because we've gotten an inspection. The second is now we have an indication of whether or not there was any damage to that product. And if there was any damage to that product, then we have evidence of whatever, let's say it was, one pallet out of 26. Obviously, that's far less substantial damage than if the whole product had just been disposed of. So then we can mitigate our damages for the 25 pallets that are still in good condition.
So the inspection becomes critical, and how so you should. But does it have to be a federal inspector, or could it be someone who held themselves out as a expert or as an inspector in this area?
The statute just has a broad definition. It's a qualified individual, right. And it doesn't mean that it has to be any particular person that has certain qualifications. So that's left up for the parties to decide. And certainly in the event of litigation, I could see both parties coming to the table and saying whether or not the person that was designated as a qualified individual, were they truly qualified to make a determination before the food product was dumped or how it was assessed, which leads me to some of our preventative measures and best practices, if you will, that person whom the parties are going to designate as a qualified individual should be at least set forth in a contract, that rather than just say, we're going to say a qualified individual is going to inspect the product in the event that we have concern for time temperature abuse, that's going to be, let's say, a USDA inspector.
Okay.
So we know in advance of a claim who that person or where that person, we're going to draw that resource from. Now, one other piece of this, and of course, you know, we're just kind of scratching the surface on a lot of this, so I'm just trying to give our audience here some key pieces of information and things to think about when these claims happen. But another component to this is if you have an insured that does get a product and they are authorized to dump it, to go ahead and get that on hands notice out to all potential people that claim an interest in the product. Right, we're just trying to shield or reduce the potential exposure that somebody would come back and say, well, you wrongfully mitigated your damages by not giving us notice and we wanted the product back, just for example. All right, so we talked about rejection. Now one of the things that has come up is the Carmack Amendment. There was some discussion.
Let me stop here for a minute. For you who, and you can't believe, Bridgette, how often when I teach this, even the basic, how many people in the audience have never heard of the Carmack. The Carmack Amendment started in 1935, I think is the thing, and it affects interstate transportation and spells out what the shipper's obligations are and what the receiver's obligations are and what the motor carrier's obligations are, and it's the law of the land, very similar to what we look at now with the Motor Carriers Act of 80 MCS 90. So for you who are not familiar with the term Carmack, this is the prevailing law handling the transportation of interstate, the claim handling of interstate transportation of property, both on the shipper and the receiver side. I just wanted to bring that up in case somebody in the audience is not familiar with exactly what that is.
Exactly, and there's certain, you know, exceptions to the Carmack Amendment that we'll talk about here, but in general terms, it is the federal statute which governs the liability of a motor carrier for cargo that's shipped. So let's in interstate commerce. So one of the things that has been discussed is the Carmack Amendment dead? Meaning that is now the Food Safety Modernization Act, our new claims handling statute with which the parties are governed. And as I mentioned, FSMA is a measure to protect food safety. It is not a claims handling statute. And so, of course, you know, we're looking for a guidance to confirm as much. And comment 45 to the Federal Register leading up to the enactment of the Food Safety Modernization Act does give us some guidance there, as there were several comments that expressed concern as to whether or not the cargo claim process, which is governed by the Carmack Amendment, it gives your reference right there, 49 U.S.C. 14706, would still be the mechanism through which damages would be sought by shippers or people who are subrogated to the rights of shippers would seek against motor carriers. So what the response in the Federal Register indicated was that in general, that they did not anticipate that this rule, that is the Food Safety Modernization Act, would have a significant impact on the cargo claim process. So, and we're going to talk about the interplay between the Food Safety Modernization Act and the Carmack Amendment, because even though there's nothing in the statute that says that this preempts any federal regulation or that it is a claims handling measure in any regard, that doesn't mean that lawyers won't get creative and try to figure out ways to make FSMA a food handling statute. So here's just some general thoughts that, you know, unless otherwise provided pursuant to the contract, the Carmack applies to interstate transportation by motor carriers, except where exempted by statute. Now, there are some commodities that are not subject to the Carmack Amendment, but this is, again, why it's very important that insureds understand what their contracts provide, because even where you have a argument that there was a shipment of agricultural products that were not subject or should not be subject to the jurisdiction of the Department of Transportation, many shippers and receivers will incorporate the Carmack Amendment into their contracts, regardless of whether there's an argument that it's otherwise exempt. So you need to be aware of that potential.
Yeah, I try to point this out when we do our classes here, that when we talk about that watermelon again, it's an agricultural product. But when does it stop becoming an agricultural product? Meaning that what happens if it's tomatoes, or where they bring it in, they grade them, they put them in bushels, and now they ship them? At what level has this been decided when it doesn't become? Because you're talking about food. Most agricultural products are food. And yet the Carmack Amendment exempts those things. I agree with you; it can be incorporated by mutual agreement, it says. But obviously, the shipper has the hammer on that part of it. Incorporate that. Is there a gray area in that, Bridgette, you see, or is that something that the laws, that court cases are going to have to spell that out as we move forward? Since we're only dealing with this a year from now. I mean, we've only been doing this about a year.
So I think that what we'd like to see it come up in these cases is that where there's been a shipment of food product that has arguably or allegedly been subject to temperature, time of use, that the Carmack Amendment, whether that applies, will be based on, number one, does it fall under the jurisdiction of the Department of Transportation, 49 U.S.C. 14706, or have the parties contractually agreed that the Carmack Amendment applies. Now, in, let's say, the absence of a contract, you'll have to look at the specifics of the shipment. Was it an interstate shipment? What was the value of the shipment? What was the product being shipped? And if it was an agricultural product, was it a raw product that's subject to one of the lists that have been, and I'm sure, Tommy, you've talked about the agricultural commodities list, which really identify those raw products, right, that are really not, they're not going through a canning process. They're not being made into a cuisine that you put into the microwave, right? There's really been no manipulation to them. So is it truly an exempt product because it's more in raw in nature and you can find it in that exempt agricultural commodities list? Or is it something that has been manufactured or undergone through some process that removes it from one of the exemptions to the Carmack Amendment? So it's going to be, again, case-by-case situation for the insured, and we'll have to see what develops in order to get a final answer on that. So kind of seems to my theme for the day, Tommy, is, are your insureds reading their contracts? I'm harping on this just because I can't tell you how much that we see that the insureds are focused on making sure that there is profit and their businesses are successful, that they are just enthused to get a contract, whether it's from a broker or a shipper, to get a great lane and revenue into the business operation without reading the contract and understanding what their exposures are. And now, with the Food Safety Modernization Act coming into play, there's been just a number of modifications that are being proposed to insureds that are incorporating the Food Safety Modernization Act, and that can be come in the form of an amendment to a contract. It can be just a completely revised transportation agreement, or it can be certifications that shippers and receivers are asking motor carriers and brokers to sign. And then in turn, brokers, of course, assigning and delegating those duties down to motor carriers. So what the regulation says is that an entity that is subject to FSMA can reassign its duties by written agreement to another party subject to FSMA. So that kind of goes back to our discussion, right? What is a non-covered business? And if you're a non-covered business because you have less than $500,000 in annual revenue, are you truly an entity that is subject to FSMA? And I think the argument would be that you're not, but that is yet to be seen, right? We don't have any specific guidance on that. Now, if you're not subject to FSMA, that doesn't still mean that that shipper or receiver, in exchange for tendering that business to you, is not going to contractually require you to sign those endorsements in your contract that says you will agree to be bound by the Food Safety Modernization Act and you will comply if you want our business. In which case, if that insured breaches the FSMA provisions of the contract, you might have a cause of action developed on the shipper side for breach of the Food Safety Modernization Act. And that's going to lead to an interesting discussion, Tommy, because a lot of what comes down the pipeline when there's cargo claims is that CARMAC completely preempts all common law causes of action, right? So now we have the potential where you're going to get a breach of contract claim because of a violation of FSMA and a CARMAC amendment claim potentially in the same complaint. So we're gonna kind of talk about, when we get to our cases here, how that could potentially develop. But the bottom line here is we need to make sure that the insureds understand what their exposures are, because if that language is getting put in their contracts and their liability exposure is now changing, that's an important conversation to have with their agent to say, I want to make you aware of the contracts that are coming in through the door, whether it's through shippers or brokers, and do I have coverage for this in the event of a claim?
And the other part of this is, you got to remember, contract, again, correct me if I'm wrong, the contract can be an ongoing contract with a shipper and a broker, or excuse me, a shipper and a transportation company, or a broker and a transportation company. But it also could be that bill of lading where your insured's only picking up the one load from that one person at one time, and that bill of lading, your driver signs, who never reads that, could incorporate some of this wording. So, you know, one of the things that I try to emphasize in the classes that I do, Bridgette, is the driver has to be knowledgeable enough to understand these things, so that when they sign and receive goods, they make sure they live with the contract requirements of those that's imposed upon them by the shipper. And so often we don't train the drivers in that area. So I totally agree with you. This is a big concept here. And then find out from an insurance coverage standpoint who our insured customers are. And, you know, every policy can be different. And my standard wording is just like you saying, you don't ever issue an insurance policy until you've read the policy, and then find out what the insured does and see if there's any loopholes in them and point that out. So you emphasize the same thing I am. Let's move on then, Bridgette.
Exactly. So here's just an example, and I could have gone on with a lot of examples, but we don't have time to go through all the potential wording that you can find in these revised contracts. But here is one where it says, if the shipper or the shipper's customer requires a cargo seal, the absence of a seal or seal irregularities at destination shall be sufficient to consider the shipment unsafe and a total loss. Right, and we've seen variations of this even before the Food Safety Modernization Act, but now the receivers are saying, well, if we don't have a seal and there's been a seal that's been required, or there's some irregularities to the seal, that could be evidence that the food has been subjected to some kind of abuse during transport, and now the receivers are saying, that gives us a right to reject under FSMA. So instead, now what we want to do is pull in the language of the Food Safety Modernization Act. Let's have us help us in this regard, and say that if a cargo seal is required and there's been notice of lack of a seal or seal irregularities, that instead the shipper shall give the broker, or if this is a broker contract or it's contracted motor carrier, the opportunity to perform an inspection before the shipment is disposed. Right, so we're not saying that now the lack of a seal means that the product is damaged, right? We've seen that argument come up before. Instead, right, what we're saying is, okay, receiver, we understand that the lack of a seal or seal irregularities may give you reason to believe that the food product has been compromised during transport, and you have a concern under your obligations under the Food Safety Modernization Act to make sure that that abuse has not occurred and that the food is still safe to pass into the stream of commerce. So what we're saying is, okay, when we're the motor carrier or when we're the broker arranging the transportation and we're contracting with our carriers, at a minimum, we need to make sure, again, that inspection is done before the shipment is disposed. so that as the insured, either if it's a motor carrier, obviously that can be subject to the Carmack Amendment, or if it's a broker looking at just the liability exposures, that before that shipment is dumped, we have some evidence of whether or not it's been damaged and whether we can at least get salvage credit, right, for that product. So shippers are designating approved inspectors, and here's what is their role in putting cargo back in the stream of commerce. We talked about it doesn't define qualified individual to perform inspections. This is left to the parties to decide under FSMA. Now, here is one issue that has come up, and we're talking about revisions to contracts, where shippers and receivers are advising that they want to have access now to the carrier's records or the broker's records if they've delegated duties onto those parties. So another reason to be aware of what's in that contract is, are you opening your doors to allow your customers to come in and conduct these audits? Now, the Food Safety Modernization Act says you can keep these records off-site, but what I'm seeing is now customers changing that and saying, well, we can come in at any time to audit your records, because their concern may be that they could be looking at some potential audit from an FDA perspective. So they want to be able to be prepared to show that not only have they been compliant, but also that whomever they've delegated their duties to under the Food Safety Modernization Act has been compliant. Because what happens, for example, in the shipper's concern is, was there an improper delegation of duties, or is there, what is the potential exposure for them if they tried to delegate this to an entity that wasn't a FSMA party? And so some of this will have yet to see how this plays out in an actual federal FDA enforcement action or audit. But what shippers and receivers are doing is they're preparing for that event. And so we want to make sure that we've complied either with our customers' requirements, or we've narrowly tailored what documents we're going to allow our shippers to have access to. Maybe it's no more than what we're otherwise required to have in the event, let's say, of a DOT audit, and those same shipping records, for example, would be made available. Here's just briefly the 12-month record retention requirement that the parties that are looking and being subject to FSMA can work with their consultant or with their team to ensure that they're complying with those requirements. And here's just the reference to the statute that I mentioned about off-site, provided it's 24 hours that can be, those records can be obtained. Here's the one that's going to cause a lot of heartburn with the Food Safety Modernization Act and the DOJ teaming up with the FDA. And this is provided in the statute that this could be a plaintiff's, this regulation could be a plaintiff's dream come true, right? Because now you've got this DOJ potential criminal penalties plus these burdens coming down on shippers, receivers, loaders, and carriers. So from a criminal perspective, the DOJ is having authority now to enforce this regulation, and it provides a civil penalty of up to $50,000 for each instance in which adulterated food is introduced into interstate commerce. This is why we're seeing the drastic reaction of shippers wholesale just dumping product if there's been any indication that the food has been compromised, is not putting it back into the stream of commerce. And then in severe cases, the civil penalty can be up to anyone proceeding $500,000. And this is a company or individual that violates the law, right? And in addition, there can be misdemeanor charges, and it's regardless of whether or not there was an intention to distribute the adulterated food. So that could lead up to 1 year in prison in addition to those fines. So this is right out of the statute. So wow. This is giving an enforcement mechanism to the federal government to really take a hard line to ensure that these parties that are subject to FSMA are actually following through with the regulations.
Which means that now the shipper is vulnerable. If they're a big company like that, knowing that they're on somebody's radar screen, then they've got to be as prudent as possible to not only to audit our motor carrier, but also to make sure that what they receive from our motor carriers have not been adulterated. This gives them again additional hammer, does it not, to dispose of these things and to come and do an audit. You don't need to react to it because I think you have, but you can disagree with me if you want to.
No, but no, I think that is precisely why we're seeing the wholesale revisions in contracts and the measures that receivers are saying that we're just going to dump these products because of the teeth that this regulation has. Now, that's where we have some disagreement, that there's not an obligation that the receiver has to reject, but they have to make sure that if the receiver has some evidence that the food was compromised during transit, that they obtain an inspection before it's introduced back into the stream of commerce. Right. So this is where the receiver has evidence that the food has been compromised. Let's say the driver failed to set the temperature, the receiver knew about it, or maybe they didn't know about it and somebody was negligent in picking up on that fact, and now you have all this, let's say, meat or whatever product it is that goes into the stream of commerce, and hundreds and thousands of people get sick. Here's where the enforcement action comes down the pipeline. So the thing to be careful of is that adulterated food is one measure, right? You're putting adulterated food in interstate commerce, and there's very specific definitions of what it means to be adulterated. But for our purposes, for the Food Safety Modernization Act, as it pertains to carriers and brokers, shippers and receivers and loaders, of course, is that if there's been a failure to comply with the Food Safety Modernization Act, that by definition will constitute adulteration. So you don't have to fit food into one of the other statutory definitions. All right, so here's where we're going to have some fun, Tommy.
All right.
Here's where we're going to talk about the cases that could impact a claim where the Food Safety Modernization Act comes into play. So let's run through some of these cases here quickly and see what could happen in the event that a Food Safety Modernization Act cargo or shipment is implicated. So here's a recent case that came out of the Northern District of Ohio, and very recently, September of 2017. And here we had a plaintiff that had purchased for $25,000 38 used metal towers containing telecommunications related computer equipment. All right, now right away you say, all right, well, this is not food. No, this is not a food shipment. That we're going to look at general cargo, but what we're going to take from this case is some of the issues that were explored in this case that could impact a food shipment. If we were to say instead of $25,000 worth of metal towers, it was $25,000 worth of meat. Well, let's explore the facts a little bit further. So we had 38 towers. 25 of them were loaded onto the trucking company, W.W. Rowland Trucking Company. And that was made by arrangements from the broker Schneider Logistics. In this case, the shipment was accompanied by a clean bill of lading. And Rowland had a no-touch policy providing that its drivers are not responsible for loading shipments and are not allowed onto the loading deck. However, when the truck arrived at the plaintiff's facility and the doors was opened, plaintiff's CEO observed that some of the equipment towers had fallen over. Damage to 5 of the pieces was noted on the bill of lading. This is an important fact. And the CEO testified that he had made the decision to scrap the entire load as soon as the truck door was opened without conducting any tests, which he considered to be cost prohibitive. So the plaintiff claimed damages in excess of $160,000, including the cost of and lost profits on all of the 38 used towers. So the issue in this case turned on whether the plaintiff met its burden of proof on the elements of damage to the shipment. So what the court did is it went through our analysis of the Carmack Amendment, and we touched on this briefly, right? This is that the prima facie case under the Carmack Amendment, this is what the plaintiff has to satisfy in this case, was that the receiving carrier received the good in good condition, that the cargo was lost or damaged, and the amount of actual loss or damages. All right, and there was a discussion that this court went through first of these elements. And the first is talking about whether the shipper met its burden of proof that the carrier received the product in good condition. And I won't go into a lot of detail about this, but the court did have the discussion about how a statement in the bill of lading as to the condition of the shipment being in apparent good order is prima facie evidence that the shipment was received in good condition. And this, of course, there's a lot of case law on this, but part of that goes into provided that the cargo was not packaged in a way or that permitted its inspection by the carrier, so that you're able to actually identify, some of this by looking into the trailer, which was one of the things that they were able to do. That there wasn't anything that prevented the cargo from being inspected. In this particular case, the doors of the trailer were open and the equipment towers were accessible and unsecured, so there wasn't really a dispute as to whether the product had been damaged, and rather the court found that the shipment had been received in good condition. So in our shipments of food products, however, let's say we're looking at TV dinners, well, you may not be able to tell, right, from looking at the box whether the food was in good condition or not.
This is where you need to check the temperature, though, and things like that of what it too. This is
right.
The driver understanding these things before they sign that receipt. Yeah,
Correct, right. So this is where your loader has to make sure that the trailer is then pre-cooled at the appropriate conditions to receive the TV dinners, and that there's nothing, let's say that on the TV dinners where the packaging has been crushed, or there's any physical or other evidence that the food in those TV dinners has been compromised, just for example. So let's move into the heart of this case, which is in the other prong, which is whether or not there was actual loss or injury, that is, or damage to the product. All right, so in this case, the CEO had made this determination based on his evidence by briefly examining the equipment for approximately 30 minutes that the shipment was going to be scrapped. None of the 25 pieces of equipment were tested. And it wasn't as though testing that product was cost prohibitive. Okay, according to the CEO, the cost of testing that product for the equipment was roughly, could cost $2,000. And he valued the pieces claimed between, $50 to $15,000. So clearly, at least for a portion of the pieces, the cost of testing would not exceed the value of the piece. So that's an important element. If this was a food shipment, what would be the cost to test that food product if it's been potentially subject to time temperature abuse?
Call the inspector up.
Right?
Or have the inspector come. Right.
Exactly. So testing, in this case, even a portion of the pieces would have served as proof of damages, so long as the sample is sufficient to indicate fairly the quality, condition, and nature of the damage as the whole cargo. Right, so the court says conclusory statements about the condition of the pieces are insufficient without further evidence to establish that the entire shipment was damaged on delivery. So this is really important because this is what we're seeing happen in food shipments, where receivers are saying, is it lack of a seal, or is it not having immediate access to temperature requirements, or some other evidence that there's been some compromise to the product, and making the decision as the CEO did in Carrier Services Group by just saying, that's it, this is scrap. The whole thing is scrap. but not really doing any testing to establish that, in fact, all of the towers that were transported by the trucking company, Rowland Trucking, was in fact damaged. So in that case, the court ended up saying that there was damage to, as indicated by the bill of lading, those towers, the 5 towers that have been damaged, but not as to the rest. So this kind of gives us a guiding principle of the Carmack Amendment is the statute that you look at interstate shipments of commerce, product in commerce, where there's an allegation of damages. I think one could take this case and argue that no, a receiver or the shipper still has to establish that the product was damaged. It's not enough that somebody looks and says 5 out of 25 was representative of the product, right? So that can be one scenario that could help the insured in a claim under the Food Safety Modernization Act.
And the step here is, again, how important it is to get that inspector to sign off on it. I mean, that's the bottom line here, to have something in place so if this does happen, they can get it inspected. But go ahead, Bridgette.
Right. And I know we're kind of coming close on our time here. So I put, this is another example where whether the plaintiff had made a prima facie case of damages in this instance. And this could be another situation where under similar facts where there has to be some evidence, like, and there's a lot of discussion in this particular case that we're looking at, Mitsu, out of the Western District of Michigan, talking about what is required to establish damage. So the courts are saying that there needs to be some physical evidence, right? And that there can be disputes. In this case, there was happened to be a disputed issue of whether or not that there was damages when this came up on an issue for motion for summary judgment. And because of the existence of those disputed material facts, this case was not appropriate for summary judgment. But that the issue here is that courts are still saying there has to be some evidence of damage to a product. Let's look at Star Indemnity. And this is the reason I pulled this case into our discussion is because it could be a scenario where, as I mentioned earlier in the program, we have a contract with a customer that says, in the event of a cargo claim, your liability, that is the motor carrier, will be subject to the Carmack Amendment. But in the same contract, you could also have a delegation of duties under the Food Safety Modernization Act pursuant to contract. So in this case here, the plaintiff Star Indemnity was the insurance provider for Cessna Aircraft Company. And the defendant, of course, we know YRC is an interstate motor carrier and had transported a Cessna engine. And so what happened here was that the trailer that contained the Cessna's cargo and other commodities being shipped had suffered damage involving a rollover of the trailer. And it was just this single incident of the rollover of that product. But there were other allegations here that YRC had violated various provisions, DOT regulations that are enumerated out in Title 49 CFR when shipping this product. And just one of them, for example, was that the plaintiff alleged that YRC had failed to properly observe the driver's past driving records and prevent him from operating the commercial vehicle in violation of 49 CFR 391.25.
Wow.
And so there's other, yeah.
Hiring practice being brought into cargo claims. Okay. Go ahead.
Yes, exactly. Right. So now we've got, this is very, artfully crafted here, all these different federal regulations that are getting pulled in because of acts or omissions of YRC. And so the part of the cause of action was bringing in another federal regulation. And so the question was, is the Carmack Amendment's preemptive umbrella broad enough to cover other federal statutes? So I could see the same argument being raised as, well, in defense of a FSMA violation, is the Carmack Amendment's preemptive umbrella broad enough to cover other federal statutes, which is the Food Safety Modernization Act? And here the court said no. All right, so there's, in this particular case, the federal regulation was under 49.14.704. Like, and some of the claims that could be brought under that would be violation of a tariff and registration provision. Okay, so this is an interesting case because, and I think it highlights what we might see in future claims, is that the Carmack Amendment is the claims handling provision, but the Food Safety Modernization Act is a provision there for food safety. Now, one thing to think about, however, is that the Food Safety Modernization Act doesn't give a private right of cause of action to the individual. Instead, what we're seeing is these FSMA regulations being incorporated into contract. So the question will become whether the Carmack Amendment's preemptive umbrella is broad enough to cover those contractual provisions which are being added in to the contracts, because time and again, we see the Carmack Amendment, it's an easy analysis. If a breach of contract claim is thrown into a Carmack Amendment, subject to some, there's cases to the contrary, but that the courts often find that no, there's a broad preemptive stroke of the Carmack Amendment. This, however, could open the door to potential to chiseling out a way for a shipper or a receiver to bring a cause of action for breach of a contract along with a Carmack Amendment claim if there's been a breach of the FSMA provisions. And that's why
that could be as simply as not training the driver properly, going back to why they use this, even because you've got an obligation to train the driver and the driver has an obligation to check these things. I could see where this could be something a good plaintiff attorney is going to bring up.
Right, precisely. So the issue is that we've got to be on guard for our contracts that are incorporating these FSMA regulations, that could open the door, and certainly going to lead to, I think, some cases down in the future that say there still can be a separate cause of action for breach of contract where there's been a violation of FSMA because we incorporated by contract those regulations, and there's been a material breach of contract for an insured motor carrier or broker that violates those provisions. Now, I say broker, obviously brokers are not subject to the Carmack Amendment, right? One of the nice features is being a broker, but there are certainly those instances that we know of where brokers accept Carmack liability or cargo claim just so that they can get business through the door.
All right, let's finish up then.
So,
okay.
Yes, let's finish up on this last one. And this is one that I brought into because I want to talk about what our insureds should be doing to try to limit their liability. So this is Eastern Air Express versus FedEx Freight. Again, another recent case, and out of here, my home state of Florida, Southern District, February 2017, where the analysis in this case is whether FedEx had properly limited its liability through its contract carrier agreement with the company Echo Logistics, such that its liability for the damage to the used or reconditioned engine, which was the product being transported in this case, was limited to 50 cents per pound per article, with a maximum limitation of $10,000. So one of the things, the old adage goes, an ounce of prevention is worth a pound of cure, right? And in this case, what the court did was it went through the four-pronged test to determine whether FedEx had effectively limited its liability under the Carmack Amendment. And so the court looked first to see whether there had been a contract that had been entered into with the carrier to effectively limit the liability. And so the court said that there was an agreement between the plaintiffs in this case and FedEx to limit the liability. But this brings up an important point, because what the court's saying here is that we're going to need to look at four things in the 11th Circuit to determine if the carrier effectively limited their liability under the Carmack Amendment. And that's one, the carrier must maintain a tariff within the prescribed guidelines of the Interstate Commerce Commission. Two, obtain the shipper's agreement as to their choice of liability. And three, give the shipper a reasonable opportunity to choose between two or more levels of liability, and issue a receipt or bill of lading prior to moving the shipment. So I'm not going to go into all the detailed analysis that the court went into to see if these four elements had been met, but I think it lends itself to, again, the conversation that the agent should be having with their insured and understanding, are you doing everything necessary, and are you engaging your qualified counsel to ensure that you're effectively limiting your liability? Here in the 11th Circuit, we've got these four things that have to be established. And one of them, very importantly, is the tariff. And I see time and time again that there's not those tariffs that are implemented. But think about how having these protective measures in place can be helpful in the event of a violation under the Food Safety Modernization Act. What are you doing to communicate to your customer that your liability is governed under the Carmack Amendment, that the FSMA is not going to be the claims handling statute, and here's what your maximum liability is in the event of a damaged food product claim. So it's part of the discussion of how do we reduce our risk and understanding what we're being asked and what we are communicating to our customers.
Bridgette,
so
in my basic presentation, I'm saying everybody needs a tariff, as you're saying here. And obviously you can incorporate in that tariff. I was just thinking, as you were talking, you can even incorporate the tariffs about who has the right to inspect, who the qualification of the inspector, and all those kind of things could be included in your tariff in case you get rejected. And, we teach this as a release bill of lading, which is where you get involved in the release, how they sign. But this is an important part of here. You need to, and you need somebody like you, because I'm giving you the thing on this first line on this page, someone like you do this to help them draft these things, because there's so much out there now, and the plaintiffs' attorneys understand this, that this is not drafted properly. And even smaller motor carriers need to make sure they're shipping receiving their goods and transporting the goods under a contract they understand, which should start with their tariff, and then any possible modification of that later, but at least they know where to start with.
Exactly, right. So here's my takeaway is make sure that the insured has qualified counsel that is reviewing the contracts that are being signed or that are coming through the door and that their insureds are operating under. Make sure you have that tariff. Consult with your agent to review your options so you know what the liability exposures are of the product that you're carrying. And then engage with a consultant to assist with the forms and operating procedures to ensure that you are complying with FSMA if you're a FSMA covered party. And here's my contact information for folks if they have any questions. And I have added in here for the audience in this last piece talking about consultants that can help provide solutions for FSMA compliance, and that's Iron Apple. So I'll give the audience an opportunity just to go through those presentations here from Iron Apple, just to kind of go through and see what potential solutions they have and how that may be of a resource for their insureds.
And we also have the slide from Hank Seaton, who is one of our members. He has a UFSTP program very similar to this that he's touting for clients that he has. He's, as you know, one of our friends and a lawyer who's done a lot of work in this area. So we also recommend somebody looking at either one of these sources to help your smaller motor carriers. Bridgette, as always, you bring a lot to the program, and we appreciate your time and effort today. We'll remind everybody that our next truck stop will be March 8th, 2018 at 2 p.m., and that's going to talk about the new drug testing requirements. In fact, some people not realize there's some new drug testing, new things to test for, and the own question about how marijuana falls in this, and those things we'll discuss again on March 8th at 2:18 on 2018 at 2 p.m. Bridgette, you have a great time, and we appreciate your time, and you bring all this valuable information to us, and we'll look forward to you continuing offering your knowledge and your expertise to our members of the foundations.
Always a pleasure, Tommy. Thank you so much for having me.